I can't find a seconder usually when I propose this, but I don't care. I don't need a seconder. My own opinion is enough for me, and I claim the right to have it defended against any consensus, any majority, anywhere, any place, any time. And anyone who disagrees with this can pick a number, get online, and kiss my ass.
No representation is made that the quality of legal services to be performed are greater than the legal services provided by other lawyers. I'm Harry Steele. You found the Backstory Podcast. We're doing a special police misconduct database edition. I have Mr. Raines Russian with me. How are you, Mr. Russian? How are things in Houston?
Couldn't be better. 85 degrees.
Right.
Got a couple of days left of this, and I'm going to take advantage of it. And if you listen to the podcast, you know where I'm going.
So, anyway, I apologize for my COVID, head cold, whatever's going on here. And the reason I look kind of rough is I've been on the couch for 2 days. So, hopefully I'm coming out of it or the medicine's kicking in. But anyway, we appreciate your time. I hope you found this interesting, and we'll try to get Mr. Rip's opinion on this as well.
We're going to get started again. This may be about the American criminal justice system, but we're running with Swiss proficiency right now. So we're going to talk now about a topic that I think is very timely. I think we have a great group of folks here to educate us on it. And the topic is databases about instances of police misconduct and what information they should hold and what our obligations are to make that information public. A number of jurisdictions are building these, and they're coming from a lot of different areas. So public defenders' offices are building them, prosecutors are building them, and increasingly the public is demanding them in order to get transparency in what's happening in law enforcement. The Brady versus Maryland case from 1963 established a doctrine that exculpatory information has to be provided to the defense, though there is a circuit split about whether that information has to be provided prior to plea bargaining. And
Brady's a little problematic, but typically in Alabama, they'll turn over things post-indictment, pre-trial.
Uh-huh.
But
post-indictment, pre-trial, okay.
Yeah, but the issue is it's not necessarily a public record. You have to ask specifically. Anyway, they'll get into it for us, but I just wanted to explain that nuance about Alabama.
Whether exculpatory information or impeachment information has to be provided prior to plea bargaining.
So exculpatory information would be something like the cop beats his wife. What the hell?
Yeah, I know.
Okay. I'm just explaining. I'm not explaining it to you. I'm explaining it to people at home that don't know jack.
Oh, right.
But it's, information is known by people who practice in the field about who you worry about when they're testifying, who's willing to cut corners, what corners they're willing to cut, and that information has long been held in institutional memory. Now, with digital technology, we're finding ways to make it more explicit, and the question about how that information is gathered.
Like, who are the bad cops? Why wouldn't we write it down somewhere? That's what he's saying. Instead of it being word of mouth, there should be a database.
What information should be gathered, how it should be used, and in a world where we talk about making sure that people who are being released from prison have an opportunity to rebuild their lives, how does that translate then to mistakes that somebody makes early in their career, whether you're a forensic analyst who messes up a test and later on takes a proficiency exam, or another kind of police officer who makes another kind of mistake, and how is that information then used in court or not used, and what are the obligations there? So to talk about that, we have a terrific panel. To my right is Julie Ciccolini. Did I pronounce that right?
Yep.
All right. Julie works with the Legal Aid Foundation and has actually built a database of this sort.
We need to go to New York to meet Julie. Agreed?
Looks that way.
Using defense information. To her right is Commissioner Charles Ramsey. Commissioner Ramsey started in the Chicago Police Department, worked his way up to deputy commissioner.
Ye old heavy badge you like to talk about?
And then led both the D.C. and Philadelphia police departments, where he was also the co-chair of President Obama's Task Force on 21st Century Policing, which released an incredibly thoughtful document about how policing can be improved in the criminal justice system. And to his right is Barry Scheck, co-founder and special counsel of the Innocence Project. Probably not a stretch to say without Barry's work at the Innocence Project, the Quattrone Center would not exist.
Good for you, Barry.
Because his work in helping to understand the errors and prove the existence of errors throughout the criminal justice system has created an awareness that has led other things like us to follow on literally, well, not literally on your coattails, but figuratively on your coattails. So obviously, hard to imagine a better group of people to talk about the pros and cons of this and how it should be used to balance the needs of both law enforcement and the defense. And so I think the way we're going to start this is that Barry and Julie have put together some visual aids to guide us in some storytelling. The commissioner's going to be around to throw tomatoes at it or agree with it, as the case may be, at the end, and then we'll ask each other questions. And as with the other presentations, we'll have the cards. So as you think of questions, jot them down, raise your hand. We'll have somebody come pick them up, and then we'll include that in the moderated discussion. All right? Take it away, guys.
So don't take our word for it.
So I don't know if we can achieve the lightning round efficiency of Rachel Barkow. But here's what we're going to try to do in cutting down these slides for like 23 minutes. The big overview here is that you've got to understand that the collection of information about police officer conduct using the tools of big data is going to change the criminal justice system, just as it's already changed the science of prosecution, in terms of, ComSat and gathering information about crime and neighborhoods and all those issues. Here's where we start. So the first thing is you need a backdrop as to the law. In 22 states in this country, police personnel files are regarded as quote-unquote confidential. So what this literally means, if Chief Ramsey's department actually made a finding, or some department made a finding that a police officer in a case, or even, let's say, in an argument with a fellow officer or something else, lied or cheated or sexually harassed a civilian member of the force, assuming that they're still working at a particular police department, all that information is something that if you went to get it, with an application from a Freedom of Information request, you couldn't, all right? And that's true in 22 states. I just took California off the list for reasons I'll explain at the end.
I'm gonna stop there and say that saying that you can get that information in Alabama is a misnomer.
Because of what you told me on the phone.
Right. It's just not. It's not how it really works. So I would say add Alabama to that list. I don't know why. Maybe they're not specifically excluded, but remember how I talked about Open Records Act, the podcast that we did? They did this prior to that decision.
Okay. But the two worst states in the country were New York and California. All right. Now, in 22 states, essentially, and I'll really add, there's another 16 that have limited access to information. What really happens is that the defense bar, certainly at a trial, and therefore the public, really never gets access to an adjudicated finding of misconduct by a police department or a civilian complaint review board. You don't get it until or unless a defense lawyer, just prior to a trial or a pretrial hearing, makes an application to see the police officer's file. What happens then is a judge will look at it in camera, and then the argument will go back and forth as to whether or not there's anything in that file that could be used for purposes of impeachment. And that's very, very narrow, and the standards around the country as to what that would be are pretty much all the same.
Does that sound familiar in a recent case that you and I have looked at? I mean, yes. Nail on the head. This is just spooky.
But here's the kicker, right? in 97% of trials. 97% of the time, cases don't go to trial, right? So just start thinking about the amount of information with respect to adjudicated acts of police misconduct. I'm not talking about unadjudicated acts. I'm talking about findings from police departments themselves that somebody lied, cheated, committed an act of sexual harassment with a member of the public. You'll see why I chose those in a minute. In only 12 states, right, is this actually subject to ordinary Freedom of Information Act laws. And the most instructive of all is actually Florida. There's a fantastic article about this called Brady's Blind Eye by Jonathan Abel. And he wrote it in the Stanford Law Review. I immediately called him up and I said, I never knew this. After all, my bar card is in New York and California. How come I never knew this? That's why. And then he said, here's how I figured it out. I was a reporter for the St. Petersburg newspaper. And whenever I wanted to get into the newspaper, I went down and I filed a Freedom of Information Act request for the last adjudicated act of misconduct, and I was on the front page. And then I get to Stanford Law School, and I realize that in California, not just the defense, but the prosecutors themselves never know about any of this, and they're not allowed to know under the so-called Pitchess rule.
So you're hearing from a defense attorney about this. Before it's over with, we'll hear from the chief of police. Can you imagine the prosecutor not being able to know that the police officer they're going to put on the stand has a record? Sounds crazy, right?
Okay, so that's the legal backdrop. What I want to fast forward to is a vision, all right? So a number of people have been working in this field. There is a public database that we'll talk about in a minute in Chicago, put together by a group called the Invisible Institute. Started with Craig Futterman, who was civil rights law professor at the University of Chicago, and his best friend, a great journalist named Jamie Calvin. And years ago, not too long ago, they filed a case called Calvin versus the City of Chicago that entitled them to go back and look at 25 years of police misconduct data in the city of Chicago, and they put together a public database.
How did they live long enough to put that together, dude?
Only about adjudicated acts of misconduct, okay, in the city of Chicago. What Julie is going to explain to you is that at the Legal Aid Society, which first developed its own database that we'll explain in some detail, but they have recently put out a public version of the database. And the public version of the database, the Invisible Institute, Legal Aid, as we'll explain, only consists of adjudicated findings by state and federal courts that an officer lied, violated the Fourth Amendment.
Adjudicated cases.
So when it says only adjudicated cases, are they talking about just cases that have gone to trial and been resolved?
Yes. Or the police, whatever, review board reviewed it, and, you know, let's just say you were found to have done something wrong. Doesn't mean you lose your job because it's a union job. Anyway, they'll get into the union stuff here in a minute, and I know that's going to be a Debbie Downer for you, but it's just how it is, dude.
Committed, used excessive force, or a settled civil rights case, or a finding by a civilian complaint review board, right? All those are public acts, as well as overtime, which she'll tell you about. That's a tremendous tell, and the rosters of the police officers. So that's number one. That, generally speaking, would go into a public database, and the way Legal Aid has it in New York and the Invisible Institute does it in Chicago, if you're a member of the public, you can literally look at that online. And as Julie will explain, the real genius of the legal aid lawyers is that they walk into court at first appearance, they put the police officer's name into their phone, and they see, just for the first part, all the public data. The Defender database is going to include all the public data, but it also will include information that lawyers get from clients, information that lawyers will share with themselves. I had this officer at the last appearance. Maybe he wasn't truthful. There's a lot of arrests at a particular precinct. Julie will tell you more about it.
Can you imagine how powerful that would be for defense attorneys to be able to leave each other information like that about truthfulness? And
but wouldn't some defense attorneys see it as somehow work product invasive?
No, hell no. I mean, it'd all be voluntary. I mean, you know, if I ran across a bad cop in a case and, well, just think about the seatbelt case, right?
Yeah.
I'd leave a note about that and the whole deposition in that case.
Yeah.
On a database like this.
At that, and we'll call that work product information, okay? The prosecutor database. Prosecutor databases now in a number of jurisdictions, what they are collecting is, frankly, not as much. They wish they had as much of this public information because they're not doing it as rigorously as the defense bar. But certainly in Chicago now, Kim Fox will look at the Invisible Institute database. She'll have that. The defense will have it. But they also have their own reports from prosecutors saying, we're not too sure about these officers. They may not have told the truth in the following cases. Here are patterns that we see of maybe Fourth Amendment violations. They'll have their own internal database as well. Now, finally, something that both prosecutor databases have and defender databases have is that both of them, and again, the defense does this more extensively than the prosecutors, and they want to do it as extensively as the defense, but they complain to us they don't have the money. I don't understand it. She's just a genius, so she gets it faster. But what it is that they will trawl the social media sites of police officers. Now, the reason why we don't believe that that should be in a public database is that sometimes will capture information where an officer says something, and believe me, it happens, that's just nuts, right? They'll see something on television, they'll respond in a way that shows racial bias.
Or they were at the January 6th insurrection, you know, that kind of stuff.
That shows intemperance, and also sometimes they'll include pictures from the crime scene that they put up on social media. That happens. All that kind of stuff is potential impeachment. It's potentially something that a police chief or a prosecutor is going to want to know about the police officer. The defense will certainly use to impeach them. But when you troll a social media site, you're also going to get a lot of stuff that just generally shouldn't be in the public domain, where people are just talking online. It's all public data, quote unquote. But it would be a bad idea from a policy point of view to put that up into a public database. Now, that's the vision of how this ought to work. I am telling you right now that in the city of New York, Legal Aid invented this database. When some of us found out about it, the district attorneys found out about it, as Julie will explain, it changed their behavior completely. And now they like to begin to communicate with each other because they begin to find out things about cops that both sides really want to know about and that the police chief should know about. All of a sudden in New York, our police chief at NYPD, after a blue ribbon report by Mary Jo White and Barbara Jones, have now told the police commissioner, you know, you really should try to amend the New York law and have adjudicated acts of misconduct public, and they should go further than that. But the tide is really changing, and we'll tell you in a second about California. So, oops, I screwed up. Here is the third part. When you have these three databases and people are communicating with each other about the behavior of police, and I have a feeling nobody wants to know more about this than the police chiefs themselves. Frankly, the people that are fighting to protect, as they should, they're the police unions. They're the biggest obstacle to changing these laws. But there is another idea that has been out there for a long time that Chief Ramsey and the Commission on 21st Century Policing heartily recommended. And these are what's known as post-decertification statutes, police officer standards and training decertification statutes. And the idea behind these statutes is that police officers are licensed, should be licensed in a state if they have a certain amount of training, and then if they do something that gets them sanctioned by internally within the police department, they get decertified. And if they're decertified, it should be reported to a statewide entity that keeps track so the officers don't go from one jurisdiction to the next one without anybody knowing about it or to another state. Unfortunately, as the 21st century report.
So do you see that little note down at the bottom that says similar databases exist for doctors through insurance companies?
Through insurance companies, right.
Okay, so are you aware that all the insurance companies have a database on lawyers? And
it doesn't surprise me.
Okay, well, listen to this. You, as a lawyer, you have a rating on that database, and guess what the rating's all about?
What?
Whether or not you'll take a lowball settlement or not, or if you got the sack to go to court and actually fight for your clients. So what do you think? Huh. What do you think all these billboard lawyers' ratings are on those things?
I don't know. I mean, honestly, billboard, I mean, that's a different conversation for a different podcast.
Yeah, true.
Because I think the billboard lawyers are notorious for taking lowball settlements because they farm out everything.
That's right.
You know, people like Morris Bart and Jim Adler haven't been inside a courtroom in God knows how long.
No representations made that probably legal services provided by other lawyers is any better. But it's
a fact. I mean, it's a fact. Lawyers, personal injury lawyers on a massive scale like that deal in massive, you know, statewide and region-wide lawsuits, they farm out most of their cases.
Yeah.
And so their algorithm, the algorithm could very well place them in the lower tier, to be honest with you.
So I just wanted to throw that in there. There's absolutely databases that have ratings for whether or not you'll take a lowball offer or not. All right, let's continue.
It showed there's only really two states in the country that have effectively pursued this, and that's Florida and Georgia, mostly Florida. Recently, just recently, as this whole idea of databases emerged, our friends at USA Today just published an article last week about 80,000 cops who they had found had committed crimes, essentially. What they really did, and we spoke to them yesterday, is what we suspected is that they went out and they looked at all the police officer decertification data. But the first thing to know is that even though you may have been eligible for being fired for having committed some act that a police chief might have decided, you know, merited punishment or even being fired, that doesn't mean that you really would get fired, because there would be an arbitration, there would be a fight, and you may or may not be decertified. So that is a huge issue in this area. But if you think about it, if you have all three of these databases, the public knows about things as well as the prosecutors and the defense, and they're all communicating, and there's a real police officer standards and training decertification statute in every state, and a national index, as the Obama 21st Century Commission recommended, this would do a lot.
Now, can you believe that there isn't a national index for people who have lost their peace officer's license?
There should be, and it's something that was discussed many moons ago, and I'm not sure how far they got with implementing it, but it's definitely something, because we ran into this back when I lived in Mississippi with a police officer who had been discharged for psychological reasons from his department, got hired at ours, and nobody knew it. And our whole claim was, well, why didn't you know it if you did a background check, if you checked references, et cetera? Well, it turns out that, you know, the thin blue line covers things like that.
Sure.
And
notorious for it.
It's something that's been discussed, and I'm wondering why nobody's really gone hard with it, and if it's the unions that are holding it up.
Well, the unions in the Yankee states, the sheriff's associations in our state, and this county commissions association, because they're not in favor of changing anything related to the sheriff's immunity and duties, because they don't want the liability.
A lot to professionalize policing in this country, and I really believe it. And the most important point I really want to make to you is that there is so much adjudicated acts of misconduct by police departments themselves that none of us know about because it's all ordinarily just revealed, or the only opportunity you have to get it is that as the case begins. So very quickly, local information that Philadelphia people would be interested in. That's the office of this man, Brad Bridge. I went from Harvard Law School to become a public defender here in Philadelphia. He is one-person institutional memory. And what Brad did is, because he kept track of every police officer in this town that ever got convicted, certainly by federal authorities. So, for example, one day, Lynn Abraham, district attorney in Philadelphia, not wont to do these things, dismissed 158 cases because Brad had tracked police officers that had been involved in actually dealing drugs, stealing it from drug dealers and, sending it out. And the federal indictment essentially said, these are not the real dates, but on September 1st, 2000, this police officer became a criminal and started acting illegally. Now let's look at all the cases after September 1st, 2000 to see whether or not this officer who was engaged in criminal activity gave material evidence at the trial. If the officer gave material evidence at the trial, then the conviction should be vacated and the prosecutor should decide whether or not they had other evidence to re-prosecute, and they decided they didn't. So
what do you think that would look like in Baldwin County if we went back and reviewed all these cases? After we found out who the criminal cops were, you think we need another tower at the jail?
A new wing, no doubt.
158 cases, Brad got dismissed in one day. And when everybody was wondering what to do about Meek Mill and his parole, Brad said, I know that cop, right? And if Meek's group, Rock Nation, had known about it, they would have saved a lot of money if they had just gone to Brad Bridge rather than spending on a lot of other people that didn't know what they were doing. Here is the city of Chicago. There is a detective named Watt who became a criminal. Jamie Calvin at the Visible Institute wrote a lot of articles in The Intercept. He was indicted and convicted. He, too, was running drug operations in a housing project in Chicago. And since Kim Foxx came to office, that's Josh Tepper of the Exoneration Initiative.
So when I was the county administrator up in Conecuh County, we had a similar operation going on at one of our housing projects being run by our narcotics detective, of course, who kept his peace officer's license after threatening me and going berserk. Anyway.
From the University of Chicago, one of the clients, as many as 83 cases now on the same principle have been vacated based on the fact that Watt and his cohorts were the ones that gave material evidence in the case when it was already, we now know they were engaged in criminal conduct. That's a case we did in New York. We don't have time to do. Same principle. Okay, Julie's going to tell us about what is in the legal aid database, and what astonished me is the day I...
So you remember the Ant-Man, E.O. Wilson? Sure. So his legacy isn't the 7,000 different phylum or genus or species of ants that he discovered. It's his database, the Tree of Life genetic database. And he just died like 3 days ago. It's very coincidental. This is what we need to do here. This is, if we're the people to try to set it up here, get with legal aid, get with whoever we need to, I think you're going to be impressed by this database and how they curate it and everything, Rain. So I think this is a natural progression of our podcast. So let's check it out.
I found out that legal aid lawyers were walking into court. They went in and they hit their cell phones, their smartphones, and all of a sudden they had all this data. And Rachel was my witness, because one day you and I were sitting with Cy Vance, and all of a sudden they said, you know what we're going to do? We're going to reveal all this information just when the lawyers come to court. And I looked at you and Bruce Green and said, what happened, right? And then I met these people and I found out what happened.
So hi, all. I'm Julie Ciccolini. I've been at Legal Aid for 5 years now, and when I started there, we had an idea to start electronically collecting all of the institutional knowledge that we had about past police misconduct. So each of our different borough offices had a lot what looked like that picture of all of those files.
You've seen Inglourious Bastards, right?
Yeah, of course.
Say her last name in the voice of Aldo the Apache. Ciccolini. Come on, Rains, give me one.
Ciccolini.
Ciccolini.
This is what we knew, but it was very disjointed, collected in different areas. Some were scrapbooks or spreadsheets, and we wanted to just put that together. So at least as an institution, what we had known, what we found out about, is all collected in one place, and our attorneys can access it. So I just want to go through like the sources of what we actually are putting in this database. The information that's disclosed to us through Brady letters. So prosecutors do have an obligation to disclose some police misconduct to us, but that doesn't happen in a timely manner, or it doesn't have to. So when you're negotiating plea deals, when they're determining bail, no mention of police misconduct has to come out. So our idea was, at least if we track those Brady letters, the next attorney at arraignments can look that up and already know what that prosecutor will eventually disclose. Similarly, if a cop switches between different counties and that information gets stuck with this prosecutor, now Cy Vance doesn't know about that information, it's not being disclosed in York County, we still know it's following this officer. If we successfully get internal affairs records or personnel records disclosed to us because of a successful subpoena, we'll track those as well. And so in order to get that subpoena, though, we have to write a Gissendaner motion, and Barry explained this briefly, but you kind of have to make a case to the judge that there's something in that officer's file that's relevant to your case. But you have to do that without knowing what's in that file. And so we were thinking, what other sources of misconduct information can we...
So just how in the hell are you supposed to swami that out and guess what's in that guy's personnel file?
It's
asinine.
I think we're once again dancing into the area of here we are, proponents of anti-facial recognition software, of anti-surveillance stuff, yet we are seeking to really support the exact same thing just for our people we consider to be our opponents.
No. And this is ensuring the system functions properly. That's all this is, in my mind. And it's information that defense attorneys ought to have.
The same tactics and the same information compilation that we rail against on a regular basis.
No, these are convictions, man. These aren't the police have information on everyone who's been convicted of something. Where I have a problem is this master name index bullshit that they're keeping on everybody who gets a pistol permit. That seems to be the basis of their master name index here in Baldwin County, and they can put whatever they want to in it. That it has nothing to do with anybody committing a crime. And in this case, and you'll see there are 3 different levels of access. So let's go ahead and listen to her, let her explain it all.
We gather so that when we go to make that case, we have a better idea of what might be in that file. So we look to media. A lot of times there's, in New York, our regular daily news and post articles, almost daily, articles about police misconduct. And when I first started, I was like, I'm not going to copy and paste this article about an officer planting evidence on a client. There's no way he's still going to be a cop. Found out, to my naive, found out that actually that officer might be put in a rubber gun unit for 3 years, but typically after 3 years of being hidden from arresting our clients, they get back on the street, back in a unit, and start arresting our clients again. So important to look to just the public misconduct coming out. And then we also track social media, like Barry mentioned. If we want to go to a little deeper dive on an officer, we'll look at what they've posted on social media. So there was a cop who notoriously posted racist comments. He would post images of cases, and I used him in my trainings when I went and trained our defense attorneys on this database. And eventually one of our attorneys got to cross the officer on that information, and the judge said, make sure that's in every DA's office and it's disclosed on every case going forward, because it was that egregious. And then criminal court decisions. So if one of our cases, a cop is caught testifying, or there's a suppression decision because maybe the officer said, from 20 yards away.
Did you notice that legal term of art the young lady used? Testifying. I love it.
I saw a bulge in this officer's pocket, and then we just saw those presentations about eyewitness identification. We actually looked because there's absolutely no way you had probable cause to search. There's no way you could have seen that bulge, and that evidence gets suppressed. We're tracking those decisions as well. And then we look to civil rights lawsuits. So PACER is a federal public database where you can access every day. I go online, search for all the lawsuits filed against police officers, download, summarize them, actually tag
Ain't nobody
them
got time for that.
themes, and put them in the database. And we are lucky enough to have a great case management system at our defender's office. And so every case we arraign, we're tracking the officer on it, the charges, the date and time. And through that, we can find a lot of.
So, Raines, they're in New York City where they can get interns, like brilliant people, to be their slaves, essentially. Columbia Law, 3 L's at Columbia Law, people working on their, instead of clerking for a judge, they got to work for legal aid for a year and work on things like this. Sure. Do you know something interesting about Alabama? We don't have a law school in South Alabama. Do what?
Well, Troy is what? There's no brilliant people in Alabama?
No, there's no law schools. So Jones School of Law was finally accredited about 10 years ago, and it's at Faulkner University in Montgomery, if you want to call that South Alabama. But there's no law school in Mobile or Baldwin, anywhere through the Black Belt or anything. Montgomery's your closest bet. So we wouldn't have the resources that she has at her disposal, but maybe, anyway, I'm just spitballing it. It's a damn shame that we don't have University of Alabama Law School down here in Mobile. Maybe our new Joe Bonner can get us a law school down here at USA.
Of interesting themes and insights into misconduct. So a couple examples: we had an officer who was only arresting Latino males for forcible touching. It was at a time of day when the subways in New York are crowded. You get in, you're like this. And we found that every single complaint or confession that these men were making was handwritten in Spanish, and it was the exact same confession over and over again. We've also seen themes of officers going out and doing specific sweeps for types of charges, or attacking, certain demographics of men in certain streets. And so looking to that and including that information in our database has also been really helpful. And then lastly, public disciplinary hearings. So like Barry mentioned, the whole point of this database is because police personnel records are confidential in New York State. But if the department substantiates findings against this officer, meaning they find they actually did engage in misconduct, an officer can choose to go to administrative trial to determine their punishment. And so those administrative trials are actually public, and my poor interns go and sit in on them every single day. And they just write down, everything we can find out about that case, which we can later use in our motion to get the real records. We had one time where the intern came back, emailed the attorney, we searched, okay, all of these attorneys have active cases with this officer. And one of the attorneys replied, "That's funny, that cop was supposed to show up on my case today, but the DA told me he was out on special assignment." So his special assignment was, determining his punishment. And so I think that's overtime. I missed one. We do actually get, through just FOILs to the payroll administration, all of this salary data and overtime information for all of the cops in New York City. It's how we create a roster of who's actually working in the city. And overtime data can, in some cases, be very informative. So last week I did an analysis and I found that officers who are making the most overtime are actually also sued at higher rates. So it's actually very in certain cases, it can be very enlightening if an officer makes an arrest at the end of a shift, and you see that officer is making 1,000 hours of overtime a year. There might be a different reason for why he made that arrest, because he gets to stay and fill out the paperwork and earn overtime on it. So we track that as well. And then this is just a little picture of the database. As Barry mentioned, it's a web app. So our attorneys have this on their phones, on their tablets, on their computers. Wherever they need to access it, they can pick it up and search for police officers. We also share this with all of the other public defenders in New York City, and then other special civil rights organizations. So the Innocence Project also has access. And we collaborate and share information with each other. So if there's a suppression decision from our partners in the Bronx, they'll send that to me and it gets put in this database as well. So we really have covered all the bases. All the misconduct that's being revealed in court should eventually end up on my desk and in this database. And then recently, back in March, we released a public website with a subset of the data. So, like I said, every day I'm downloading lawsuits from PACER that are any civil rights allegations against these police officers, and we've been doing that for 3.5 years. So we put that up all online, along with any other misconduct we knew about this officer that was obtained publicly. And so you can, I don't think the URL is here, but if you're on a computer, capstat.nyc, you can go check it out and browse the data there. And this is just one screenshot. This is our network of associations.
So do you remember the spider graph from the bar complaint or JIT complaint in the strawman case?
Something like that.
This is like the lawnmower man version of this shit. Watch this. This is crazy.
So I know it looks like kind of a crazy blob, and I can't interact with it right now. But what this is it's a relational map of officers who have been named in lawsuits together. So these big dots are their commands, and you have little dots that are the officers in the lawsuits. And through this, you can kind of identify teams of officers or different commands that are engaging in the most misconduct. So we found this helpful. For example, Detective Joseph Franco was just indicted for perjury in New York City. If we want to know all the other officers who he's been working with, we can come here and see who he's been getting in trouble with. And we've been able to identify multiple cases where there's a bunch of other cops who are his exact team. He may not have been directly involved in that arrest. It may not have been disclosed that he was involved in that arrest, but we know he likely played a role. All right, and then the impact. So lots of you have probably done defense work, can imagine what a game changer it is for our attorneys to be able to have this information at the start of a case on their smartphone. Countless times, attorneys are standing up, and a judge is trying to set bail on a client, and we find out their sole officer witness on the case has 15 prior lawsuits for unlawful car searches, and that's the officer who's going to testify about the car search of our client, and that bail suddenly turns to an ROR. And then exposes test to lying. So, like I said, we are tracking all of the decisions where officers are caught lying on cases, where a judge finds them incredible, where evidence is suppressed, and we can use that in our next motions. We're making more suppression motions. Sorry. These interactions are struggling. Okay, so the virtuous cycle. Because we started this database, we're able to use this information in courts. We are often catching the DAs off guard, right? We knew a lot more about the police misconduct than they did, that they were required to disclose to us. And so the DAs actually created their own database so that they can fulfill their obligation to disclose this, their Brady obligation to disclose this information to us. And since we have all of the defenders working collectively, it becomes this cycle, right? They disclose this information to any of our defenders. We're putting it in the database, and next time both parties know about this police misconduct. back to you.
So, and I want to give credit to Cy Vance and his counsel, Carrie Dunn, because what happened is that when all of this started to come out, and they suddenly realized that legal aid had all this data about police misconduct. I mean, and I'm talking here just about adjudicated acts, right? The next thing that happened is that they sent a letter on behalf of all 4 district attorneys in New York to the NYPD saying, you know what? We want to know all the information from civil rights suits, CCRB, adjudicated acts internally. We want to know that, not at the end of the case, because so few cases go to trial. We want to know this right away in the complaint room when we come up with the charges. And I must say, as soon as they, we talked about that because we're on this advisory commission, Rachel and I and some others, to the district attorney in New York County, and a light bulb went off in my mind when I started thinking as a California lawyer, we see even less than that, right? It is extraordinary to think about. And that is a fundamental insight. So they have demanded all of this. And by the way, Cy had a pretty good complaint because he paid for a lot of the fiber optic cables that put all this information together. I want to see this right away. When we charge people, that's the most important thing. So that is the end of the virtuous cycle there. In the Invisible Institute in Chicago, I told you about the great work of Jamie Calvin and Craig Futterman in putting this together. There, it started with a public database. They have very pretty, you go to Citizens Database at Visible Institute, you'll just see it right away. Now, this is Jason Van Dyke. So what happened when...
So if legal aid won't let us have access to their database, maybe you know somebody in the old Chicago Times building that might give us access to theirs. You know what I mean? All is not lost. There's all kinds of databases out there.
And they put together this database at the Invisible Institute. And they're a group of journalists and academics, is that they began to discover information. And Jason Van Dyke is the officer that fired 16 shots into Laquan McDonald, right? And they showed that he had all these police complaints that were ruled unsubstantiated and other charges against him. So a lot of what happened was not unpredictable. And then, of course, they got leaks from the police department that there was a tape. And then they filed Open Record Act requests to get the tape. And they found the tape. And the police chief was let go. The mayor decided not to run for re-election. Van Dyke was ultimately convicted, although the other officers with him who were charged with covering up were not. They were acquitted. But the point was that turned the whole place upside down. Now, the one thing I want to say about the public database, again, this is a virtuous cycle. And I can't stress this point enough, because so few times can you actually fund and put something together that involves all stakeholders, prosecutors, defenders, the public, and ultimately the police to take action, where you can predict ahead of time that there's going to be change just by the gathering of this data about which there should be no argument because you're not entitled to your own facts, right? Certainly a public database. So
you're not entitled to your own facts.
That's a heavy statement.
I like it. He's sharp, man.
So in Chicago, it was not a defender database. It was the public database that led to the Defenders Now putting together their database that got police data into court, that created a DA database with Kim Fox, that went into the media, that pressured the police department to change, and helped the police develop their own data more efficiently. So the other thing I should say about the Invisible Institute, and it's the kind of thing that the Quattrone Center, don't tell my friends in Chicago, although this is streamed, they'll say that, could do as well as better if you had 3 databases here in Philadelphia. And that is the Quattrone Center did a lot of great research. one of the very interesting things, and I'm dying to know what Chief Ramsey would think about this, is that when they did their analysis of the police misconduct, they found that the officers who piled up a lot of these complaints, serious complaints, were not disciplined, but a lot of officers, when you look at the database who were disciplined for things that many of us might think were comparatively minor. For not showing up in time, uniforms not being right, other kinds of things like that. And we have found, frankly, in our research in New York, the same kind of thing.
Drill sergeant bullshit, your uniform's not right, your gun's not clean, your car wasn't clean, the things they do to harass their good officers. Bullshit.
So it's our view that if there is a public database, certainly in these three databases, I think it could bring some improvements to the disciplinary practices of police departments. And this is not just me saying it. I have the added support of recommendations to Chief O'Neill by, Mary Jo White, Barbara Jones, former federal prosecutors, all of them, to Police Commissioner O'Neill recently. So I think that being able to having this kind of data out there, being able to curate it and do good research off all of this data is something that would be terrific and has never happened. So let me very quickly tell you about what happened. We have now been, through the work of the National Association of Criminal Defense Lawyers.
Now, notice who doesn't have this database, right?
Mm-hmm. We have reached out to public defenders and state defenders in all of these jurisdictions, on the verge of trying to develop at least a defender database, if not prosecutor and other databases. And here's the story of California. Chief Ramsey, this is from what our conversation outside, you know this better than any of us. It turns out in California, the prosecutors don't get to know about internal police misconduct data under this Pitchess decision. And what happened is the Los Angeles Times did a groundbreaking article in 2017 saying that the Sheriff's Department in Los Angeles had 300 deputies on what they called a Brady list. People they wouldn't call to testify in court, or as Julie was saying, people in New York, we put them on what we call the rubber gun squad, right? And they wanted to give the Brady list to the prosecutor in Los Angeles. And the union moved to enjoin them, and under California law, they won, right? And the Brady list couldn't be given to the prosecutor. And what was in this article in the Los Angeles Times, we're talking about officers that had put Tabasco sauce in their shirts and said it was blood. We are talking about officers that had sexually assaulted civilians on duty. That is the kind of misconduct that the sheriffs were using to put these 300 officers on the Brady list. And when that story broke and it was all enjoined, this past year, a state senator from Berkeley, California, put in a law that's called Senate Bill 1421. And this bill amended the law, and it said, here are the following items which are now public record, right? Subject to, California has a very robust Public Records Act request. Within 2 days, all this must be turned over. But they said there's 3 buckets of information that are now public record. Number 1 are any statement of dishonesty, false statements in a report, of destruction of evidence or concealment or falsifying evidence. Anything in that broad category where there's been a finding by a police entity against an officer, all of that must be disclosed, okay? Number 2, sexual assault. But sexual assault is defined very broadly, and it's really about harassment of people on duty where the badge is being used to get sexual favors or harass people. All of that, not just rapes. They call it sexual assault in the statute. It's broadly defined in the way I just described. That's bucket number 2 of information that's public record. And bucket number 3 is that in California there have been a lot of cases which involved shootings, discharges of weapons, or infliction of serious bodily injury or death, that became controversial, and members of the public felt that they didn't get the full story. So this statute says that now all of that information from past cases that have been decided, essentially, now can be available for the public to examine. But when I say 3 buckets, when you look at the statute, they're very big buckets. We're not just talking about, a summary or something. You get to see every report, every video, every autopsy report, everything, every part of the adjudication of misconduct. That's all available under the statute. So,
crazy talk. That would never happen here. But let's keep listening.
The unions, again, of course, have moved to enjoin the application of the statute. So far, they have lost in every intermediate appellate court. My own expert legal analysis, what do I know? But I'm feeling confident that they're going to lose in the end. And probably in a few months, all of a sudden, all of this data in California can become public. The interesting thing in California is under this Pitches statute, you weren't allowed to get any personnel file information, any misconduct data that was more than 5 years old. So there was this assumption that after 5 years, police departments just destroyed it. But I had a bet with the ACLU lawyers and some of our friends, because I think they're like Chief Ramsey, why would you destroy it? Don't you want to know if your police officers are doing things that are wrong? You want to have files on them that go back more than 5 years. So it's all there. The only interesting thing is that Inglewood, California, which was under federal consent decree as soon as the statute passed, but before it went into effect, they began destroying the records openly, right? Which is quite extraordinary. Okay, so far, so many jurisdictions have had the records asked, and what's great is that now the press, coalitions of journalists have formed together, right, and are beginning to put in all these Open Records Act requests, so it's not just the ACLU and the defenders putting them in. And the key challenge now in California, and I would suggest that this can be played out all across the country, is all this information comes in, it must be curated. It must be curated in a sensible fashion, because certainly you would want to take what you're getting is the so-called adjudicated acts of misconduct file, and you want to compare it to court decisions, to civil rights decisions, to everything else, so you can begin to track it. So that's our potential future.
So, Chief, in the interest of fairness, I'd like to give you 90 seconds to respond. No, seriously, there's a lot of information that's been presented here, and I think Barry says something appropriate when he says this has to be curated responsibly and fairly. Is that doable?
It's doable, and I think it's essential. One of the concerns I have, first of all, let me just say that much of what was discussed I don't disagree with. Whether or not it would ever happen, having a public database, unions would fight that tooth and nail. We have personnel rules we've got to overcome. Unions now are able to form political action committees, which means they can donate to campaigns of politicians, and we all know the ethical people that we have sitting in our, state capitals and Congress and so forth. So that could be an issue too. But having said that, adjudicated cases I do not have a problem with. Now, when I was police chief in Washington, D.C., the U.S. Attorney, as you know, serves as the prosecutor. They had a list of officers.
If I hadn't heard this for myself, I'd have thought it was made up, okay? Just wait for it.
I don't know if they call it Brady list or what they called it, but they had a list of people they would not call to testify. I asked if they would share that list. They refused. So I was unable to take any action whatsoever. They had, at one point in time, this is, again, I never saw the list, but this is what I was told, that they had as many as 30 people on the list. Then there was another time when they had 19 people on the list, which means that Some people were being taken off the list. What's the process for getting on the list, and what's the process for getting off the list? I mean, there needs to be in place some way of being able to fully investigate a case, share it. Now, whether or not police chief does anything with it or not, that's a separate issue. But one of the core responsibilities of a police officer, or duties of a police officer, is to be able to testify in court. If you can't testify in court, you shouldn't be a cop.
Absolutely.
I mean,
absolutely.
Amen, brother. That's what we're saying.
So if that's the case, then we need to be able to investigate. It's the same thing right here in Philadelphia. There's a list, a Brady list. Now, I'm not talking about the current DA. I was not police commissioner during the time that Larry's been in office. I have no idea what they're doing. But I can tell you his predecessor, they wouldn't share the list. I got one letter in 8 years that had 6 names on it, and that was the result of an investigation that I actually brought to the FBI. It was on a narcotics squad that we had some serious concerns, and the FBI and the Philadelphia PD, were internal affairs, jointly investigated, and these 6 people were involved. And so he sends a letter saying, these people are no longer going to approve search warrants, they can't testify, blah, 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 which made sense. There were others that they had on a so-called list that I was never, ever allowed to see. And again, people get on, people get off. How the hell does that happen? I mean, I don't get it.
Good question, Chief.
And so there's got to be some process in place where if an officer is lying, if an officer is guilty of serious misconduct, and again, you got to define what you mean by misconduct, because every department is a little different as to how they define that. Verbal abuse, for an example, would be considered misconduct. Not that it's not serious, but if someone is being accused and found guilty of acting or saying something, being rude toward a citizen, I don't know if that's something you necessarily want to put on the list versus some of the other acts of misconduct. I mean, we need to sit down and think about these things. Otherwise, the list becomes meaningless if it gets so broad that it no longer has any meaning. So, but that's doable. I mean, we just need to come out with some standards that would allow it. Now, I don't know why we need 3 databases. The public database that has adjudicated cases, I absolutely don't have a problem with. But when I saw the one slide, it said defender database, for an example. It also includes the public database, which, okay. But it also includes work product from clients, lawyers, and protective orders. Are these things the result of investigations that were conducted of some kind? That's additional material that's going to be added into this database. But, is it good? I mean, is it something that's been verified? I don't know. And then the prosecutor's database, internal work product about lies to the DA. Where's the investigation? That's what I just got finished talking about with the U.S. Attorney's Office and the District Attorney's Office. If you feel that an officer lied in court, fine, or lied to you, investigate it. If they're guilty, they should be policemen. They shouldn't be. It's not a thing where you lied to me, I'm a little pissed at you now for the next 6 months, but then eventually you can make it up and somehow now you're off the list. I mean, you're either on the damn thing or you're not on the thing, and as a police chief, I need to know so I can take the appropriate. I don't.
That's my big issue is
how do you get off the bad Santa
list? Not being
list?
reliable in court. I don't know how you get off that list. And if that's the case, how? All right, I get the existential question of, well, if you're on the list, how can you be a cop? I get that. But even a criminal gets X amount of years in jail. And once they're out, they've paid their debt to society. You get on a list like that, and all of a sudden you're ruined for life.
Maybe.
You're in the same, you're put in the same coat closet as Harvey Weinstein. And I want you to think about that.
I'm thinking about it.
You're talking about a cop who gets put on a list for not being reliable in court. That's it. That ruins a person. They can't be a cop anymore. And I understand the need to not want people like that serving, and most importantly, not want people like that testifying in court to anything, especially if they have a track record of being mistaken or lying outright.
Raines, why don't you do a little research and find out the last time anybody was tried for perjury in federal court in the Southern District of Alabama or in Baldwin County? I bet it's been years. I feel like
you already know the answer to that.
Yeah, of course it is. It's been years. All right. Well, the chief thinks it's a good idea, so let's finish listening to him.
Okay.
I don't need cops that are liars. I don't need cops that are engaging in serious acts of misconduct. But I can't do anything about it if the people who are making the accusation don't step forward. It doesn't make any sense to me. I think you got to be a little careful when you're talking about social media. Now, I've had cases where, in fact, we had to create a policy because the reality is technology is moving faster than the law or policy can keep pace with. And so we didn't have a social media policy until, of course, some cop screwed up and did something on social media that made us say, oh, we need to have a social media policy, right? But you got to be a little careful because there is a little thing called a constitution that also covers police officers, okay? And so if they identify themselves as police officers, if it's something that I can directly associate with their, line of work, that's a different thing. I can take some kind of action. Otherwise, you're kind of on very, very shaky ground. So you got to be a little careful with that. Also, certain information can be obtained through social media that could actually put an officer and their family at risk. And I'll give you an example. I decided to release names of police officers that were involved in shootings within 72 hours after the shooting. Needless to say, my union was not real happy about that, but I thought it was the right thing to do. Why 72 hours? One of the concerns was the social media footprint of that particular officer and members of their family. People are able to find out where you live, people are able to find out information about your kids, what school they go to, all these kinds of things. And so during that 72-hour period, I had my IT people work with that officer so they could minimize their social media footprint to a point where that kind of personal information would be unlikely to be obtained. That's just for safety purposes. And then we released the name of the police officer. So we just need to think these things through carefully, and that part of it makes me a little edgy. This whole thing about overtime. Listen, you can connect any dot you want to connect if you set out to connect it to begin with. But be a little careful about that sort of thing. The fact that somebody's making overtime, there are a lot of reasons why people make overtime. Now, maybe there's a correlation, a connection, or something like that, and there may be 2 or 3 cases you can point to. All I'm saying is be careful with some of that stuff, because one thing doesn't necessarily equate to another. And so be careful. How many lawsuits are you in? And I almost had to, I'm in a little bit of a different position, but I remember after I retired, the FBI called me up. They wanted me to renew my clearance. And why, I don't, but I said, okay, fine, I'll renew the clearance. So you go through the process, and if you have a clearance, it's not an easy thing. It's a long process, tons of questions and all that. One of the questions they asked me was whether or not I had ever been sued. And if so, how many times? My answer was, I have no freaking idea. I was a police chief for 17 years. Every time somebody files a suit against the department and the city, I'm named in it. Some of those suits I don't even know because the general counsel handles it, and I'm not even told. If I don't have to be deposed or anything like that, I had no idea. So the number of times by itself could be misleading. And the problem with databases, and the problem with public databases or any kind of database, information can be interpreted any way that person wants to interpret it. So all I'm saying is be careful. I'm not saying we don't need to have it. I was co-chair of President Obama's task force. One of the recommendations, there needs to be a national database of officers that have been decertified so that they can't get hired anywhere else. We just don't need them in our profession, period. Okay? So there are things that do need to go in a database. But one thing I've learned, and this even databases that are maintained in police agencies, perfect example, license plate readers. People love license plate readers, right? But they don't pay attention to it, right? And driving down the street, you're scanning all these tags, and every now and then you get a hot car. You may come up with a car that was involved in a crime or whatever. The problem ain't getting in, the problem's getting out. And if the only thing is that you happen to be parked on that block at the time the cop drove down the street, why should you even be in a database? And if you're going to be in it, which I understand, maybe for a there should be a limited period of time before you're automatically purged from there. Problem with databases, and you're in databases now in the private sector and all these, companies that want to sell you something or whatever. You're in all kinds of databases and don't even know it. Or try getting your name taken out of one of these search engines where people can find all kinds of personal stuff about you, your family, who your mother was, who your father was, all that kind of stuff. I went through it one time and I'm saying, why would they have all this information about me? You know how hard it is to get out of one of those damn things? And you get out and you might wind up getting right back in again through some other means that you're not paying. So I don't mean to ramble, but what I'm saying is databases are great. I'm all for it. But you've got to have strict rules. You've got to have guidelines. If you're going to do that, you're talking about a person's livelihood here. Make sure there's an investigative process in place. Well, the people that are in that database deserve to be in that database. Share that information with the right people. If they don't need to be cops, they shouldn't be cops, period. Period. But it starts with sharing information. And I can tell you right now, there are prosecutors that don't want to share it, that will not share it, even with the agency that's responsible for those police officers. So a lot of stuff has to change. And as far as the media stuff, and I think I saw something, or maybe you mentioned it, where it could be an article about someone in the newspaper or whatever that goes in the database. I mean, come on. How many of you read stuff in the media? I mean, all you got to do is watch cable news for an hour and you'll find it. Some of the crap that that's not necessarily true stuff. Have a way of filtering that stuff out so that we've got a real database that has meaning and action can be taken against the individuals that are in it, and not just something was just compiling all kinds of crap, and then when you finally do need it, it's so broad you can't even find what you're looking for. Other than that, I have no opinion.
So it actually sounds to me like we're not terribly far apart.
We're not far apart at all. I just want a process to make sure that the people that are in it deserve to be in it. And if not, then why should they be in there? And I'm not convinced that...
Kind of like my argument about the master name index maintained by the Baldwin County Sheriff's Department. Tit for tat, right?
That's what we're talking about here, or at least that's what's going to happen. That's my only problem. At least California, with their 3 buckets, and you could argue whether it was broad enough or what, but at least they defined in a way what it would be. If you're in a shooting, if you're sexual assault, if it's, at least they tried to at least take a step, and maybe it could be more than that. But something as broad as just saying misconduct. Misconduct in the Philadelphia PD could be totally defined differently in Chicago PD, different in some other jurisdiction or whatever. So we need to have some solid ground that we're standing on and then hold everybody accountable.
So I have a quick question for you, Chief, and then I have a legal question, I think, for Barry. My question for you is, did the U.S. Attorney in D.C. offer a reason for why the...
They just said they weren't going to do it. You know what I suspect? They didn't know how the hell the person got on the list. Because any U.S. attorney was able to put a person's name on the list for whatever reason and didn't have to really justify why. I mean, that's sad. But I believe that's the reason why. Now, that's my personal opinion. But if you can't tell me, what's that all about? Because when I first found out about it, and then, okay, you got 30 people on there. I asked again a few months, I got 19 people on there. How the hell you get off it? If it's that important and if that's bad to get on the list, then what's the process for getting off?
Well, it seems a little ironic that a database that's driven by transparency for police officers wouldn't itself be transparent in the rules that it has.
Well, but see, that's the whole thing. Anytime we start talking about transparency, there's only one agency who gets mentioned, and that's police. Okay? Now, that's just my personal feeling. Okay? So, I'm wearing a body camera. Okay? That's fine. I am a proponent of body cameras. I'd love to see prosecutors wear them too, because I'd like to know a little something about some of those backdoor deals that are being done in these courts. Hey,
I hear you.
All part of the same system. Am I right? Then let's all be transparent. Damn it.
Frank, we're going to be asking you for funding for Quattrone Center employee body cams shortly. Barry, my question for you is whether anybody is coming back to you with concerns. The ABA model rules for 3.8 G and H talk about an ongoing obligation to disclose impeachment information, exculpatory information. The Michael Morton Act in Texas goes arguably farther than that. What does this database do once those cases are out there for all those prosecutors? Does every prosecutor have an obligation to take every one of those police names and go back and report any of those newly discovered adjudicated acts?
Well, it depends, frankly, how serious the act is. But let's just get some law into this. I think I have this right, that the Brady list here in Philadelphia that was disclosed by District Attorney Krasner was a list that his predecessor had.
That he did not share with me.
That he did not share with you. And let's just be blunt about it. If you have a list as a prosecutor of what you believe are instances where an officer has not been truthful, right, you are legally obligated to disclose that to the defense.
Yes.
Period. And what I'm trying to point out to you is that the laws have been so backward here that nobody is ever seeing very, very serious. I mean, I find it unimaginable when you think about it, just like you. Why wouldn't the police chief know if a prosecutor, and even decades of prosecutors in a jurisdiction, have their own internal lists where they're saying, we don't trust this comp?
And Barry, just one thing. Why would I allow a police officer to make more cases if he's on a list where he's not going to be able to testify? If I don't know about it, I still got him out there working, and he's making more arrests, and he's making more cases.
Exactly. And that's why when I heard about this, and there's so much attention in the Quattrone Center and elsewhere these days have been paid to, safety experts and the idea of having multi-stakeholder solutions to problems, right, and information sharing. And this is, I can't think of a more important one, frankly, these days in the criminal justice system, because so I have mediated confidential meetings between people on the defense side and people on the prosecution side about how they can share information that they are developing themselves, right? And then, of course, the biggest, this virtuous cycle, when people begin to share information, it's really astonishing that the district attorney in New York was able to get all his colleagues together and say, I actually want to see all the evidence where you, the police department, have said that these people have committed bad acts and you have themselves adjudicated it. I want to see this at the beginning of the case. And what I'm suggesting to you is that you get everybody together with these databases and implement the recommendation that came out of the 21st century policing proposal about post-decertification. If you put all those together and we develop the kinds of rules that Chief Ramsey is talking about, and if we have public databases that are curated appropriately, and I think a good case can be made for the way the Invisible Institute has done this, we get press and academic partners to curate these databases in ways where you're not filling it with extraneous prejudicial material, which if I were running a police union, I may get very upset about because it makes officers targets, or even as we discussed, it's probably inappropriate to put the pictures in the databases of all these officers, particularly in difficult situations. But if you're really sharing information that all the stakeholders can get together because it's astonishing that people don't have this information. You're a judge, you want to know if this police officer has been adjudicated to be lying about the kind of case that is now before you where you're setting bail.
You should have it. I mean, I have no problem with that at all. The only problem I have is making sure that there is a process in place to make sure that, you know, there's been a proper investigation conducted and the officer, in fact, is guilty of lying. I mean, if they lied, they lied. And then we can take whatever personnel actions we need to be able to take. So
Julie, this dovetails nicely with one of the questions we have from the audience, which is what processes do you have in place to screen out rumor and innuendo and make sure, you know, what have you begun doing to meet that bar of curating and responsibility in the database you're building?
Right. So I'll touch on it first with the public website. So the public website, what we did is curate public information and actually just connect it to the officer. So nothing we put out there doesn't already exist out in the public online realm somewhere. It's information, we're filling a hole in information that we found police chiefs or prosecutors don't take seriously as police misconduct, and we're not investigating it. The allegations are the allegations in it, and it's on to whoever wants to use that information to look deeper. We are simply curating, pulling information from different sources together and displaying it publicly. So yes, an officer's profile may have 15 lawsuits. I'm not saying all of those have merit. It's hard to tell which lawsuits have merit in New York City because 97% of those are going to end in a settlement. So it would be up to the attorney who wants to use those to go and, you know, speak to the plaintiff's attorney, get to the plaintiff, and find out what actually happened there and how involved that officer was. See if you can get the deposition of that officer, for example. Same thing goes for our internal database. So we are kind of broad in what we include in there because our attorneys are supposed to view it as a starting point. This is, most of that information is not going to be relevant to every case. An officer can have egregious misconduct in, you know, one section has nothing to do with a false arrest or the drug case that our attorney currently has. And it's not related, and therefore they're not going to use it. They wouldn't be able to introduce that into their case. So we're just putting together what we know about that officer. Every officer in the NYPD is in the database. It's not just, oh, you hit some bad lists and now we put you in there. You're in there. We track, you know, what command you're at, your shield number, and then if we find out some misconduct about you, that will go in your profile. It's up to the attorney who wants to use that information to do their proper investigation.
But when you say you find misconduct, is this verified information or is it not? Because in one sense you said that you pull from a variety of sources that information. It doesn't necessarily mean it's verified. So, you know, when you say, you know, you got everybody's name, and if they're guilty of misconduct, how can it be guilty of something without an investigation?
So I didn't mean to say they're guilty of misconduct. There's been allegations of misconduct. So we have a civilian complaint review board in New York City. It's an independent agency, and they'll investigate any civilian complaints against the police department. Lots of those cases would close with victim uncooperative because whoever had their rights violated, you know, can't take the day off work to come testify against that officer. And so it doesn't mean that allegation doesn't have merit, but it may not end in a substantiated complaint.
I understand that, but when you start putting people's names in a database, and if the same thing was being done to you, you'd have some concerns about it. And I think everybody in here, okay? And all I'm saying is that we just need to be careful, because today I'm wearing a jacket, tomorrow could be you. All right? And so be careful. It's all I'm saying. Because it's easy to come up and you search the Times and the Post and God knows what else, and somebody says whatever. Or, you know, and all of a sudden it goes in the database. And if it's not verified, it's not verified. So even if the investigation, and I'm not even saying that police ought to do all their own investigations. Another recommendation in our task force report, especially with shootings and so forth, an outside group do the investigation. I don't have a problem with that. But do something other than just because someone said something, or you make an assumption that the reason why the officer, it was not sustained is because the person couldn't take off work. Well, maybe it never happened. I mean, that's the point of an investigation. And I'm not trying to defend bad cops. But what I am saying is that, they have rights too. And if we're going to protect right, you've got to protect everybody's rights and take steps that are reasonable to make sure that if you're going to call them out and throw their name out there and embarrass the families, the kids, and everybody else, and some of them, they deserve it, at least be on solid ground, not listening to a lot of rumors and innuendos or somebody made an accusation about somebody that may or may not be true. That's all I'm saying.
Could I clarify one thing?
What?
So we're not putting names out there. The information in the database, the defender database, is completely separate from the public information. So families aren't being smeared by any information going to this defense database. Only our attorneys are able to see that information, and the only way that would come to light is if they were able to effectively introduce that into a courtroom. Now, if a judge also doesn't believe an effective investigation took place, and there isn't a substantiated allegation, there's no way our attorney will be able to introduce that information that, the victim wasn't able to come to court. But if they are able to actually speak to that person and have them...
In other words, we're all lawyers, and we have to do things right as opposed to the way the police officers do it or the district attorneys do it. You know what I mean?
Yeah.
Come testify, that may be how the information comes to light, and the officer would have a chance to respond, right?
And I should tell you that so the courts, I think, do a very vigilant job in not allowing cross-examination on, frankly, unsubstantiated or scurrilous allegations where you can't prove merit, right, ordinarily. Many officers may not feel that way, but that is the job of judges. But I think you do put your finger on one of the very tough issues that arose when you look at the report to Commissioner O'Neill, and that is that in Chicago, and I'm sure it's true in other jurisdictions as well, the situation that Julie is talking about, where there's findings by the Civilian Complaint Review Board. In New York and in Chicago, they would use a category of unsubstantiated, and then there's another category of unfounded, right? And the unsubstantiated would sometimes be instances it's the civilian's word against a police officer, and the review board or even the internal or the Affairs Department of Police may have said, we don't think it meets the standard. The problem that has arisen, unfortunately, is that many of the officers that ultimately get in trouble for the excessive force or criminal activity, all of a sudden it gets into the newspapers, we never knew that they had all these complaints like Van Dyke, right? Which is not very good for the system. What was interesting is that in Mary Jo White and Barbara Jones's report to O'Neill, they went back and they checked about the Invisible Institute, and they checked with the head of the Fraternal Order of Police, and they said that even though the names of the officers were listed, the FOP did not believe anybody had been subject to threats or targeting or anything of that kind. But the issue is a tough one, because you want to believe that if, as a criminal defense lawyer, I don't like the idea that somebody is, where the complaint was unsubstantiated, that all of a sudden that can be used against you if it's unsubstantiated. On the other hand, a lot of people feel, I think, with justification, that many of these systems for discipline, both internally and even with these civilian review boards, that a so-called unsubstantiated complaint is not a finding that really means that there was no merit to it, and you have to keep track of all of them. And I think that's just a tough question.
It is a problem. It is tough. I don't have an answer for it, because, I look at these things too, and I don't have an answer. You do have to look at all these cases as individually. But there are some officers that have a pattern of behavior that is very troubling, that you want to take action. And, we do have a system and a process in place with, arbitrations and everything else that make it very, very difficult to get rid of police officers. I don't know how that differs from a defense attorney who has a client that this isn't the first time they've had this client or seen this client, because they're kind of like a regular, and whether it's a guy who's dealing in drugs or maybe it's a gangbanger who likes to shoot folks, and there's not always enough information or witnesses to be able to come forward to get a conviction, yet this person comes back over and over again. Right. You can make a presumption that this individual's probably not a real nice guy or bad guy, but he still is able to get out and do whatever. That happens in that world as well as the police world. We need to fix that somehow, because I hate to see it when I got 20 allegations against an individual and it's not sustained in each case, and you start to see a pattern of some kind. It's a problem. And
one of the interesting findings out of the Invisible Institute research is that the acts of misconduct was committed by a very small percentage of the police.
Just like criminals.
Right. And I do believe that if we have these public databases as well as, the others that help share information, that's what they're going to find. And in the final analysis, the key thing, I think, in terms of reforming policing, but you would know better than I would, and I really mean that, is that I do believe that good officers can't be afraid of bad ones. There is a code of silence.
Absolutely.
And that is something that has to be changed. And this kind of information sharing can create an atmosphere where the public, the prosecution, the defenders can work with police chiefs, to make that a reality. And that is, look, I admit, when our law firm sued both the police unions in New York as well as the city of New York in the Abner Louima case, right? Mm-hmm. And those are all very complicated problems in terms of 48-hour rules and investigating acts of police misconduct. But, one of the things that we were able to get out of that case was an agreement that police officers in the city of New York did not have to take a PBA lawyer. They could have a funded non-PBA lawyer. And so it is important that good cops not be afraid of bad ones.
And I agree with that 100%. And I certainly don't want to give anybody the impression that I'm opposed to having a database or I'm trying to defend cops that are doing the wrong. That's not it. I just want to make sure that we have a solid process in place to make sure that as we move forward, we get the right people are there. It's just like when we talk about, people that are charged with a crime that wind up going to jail. Again, the only people that are in jail, that should be in jail, are the ones that actually are guilty of the crime. So I just want to make sure. And as far as a culture and this quote unquote code of silence, does it exist? Yeah, sure it does. But it exists in just about every profession I can think about. I don't know how many lawyers that see another lawyer that maybe is not defending his client to the fullest extent or whatever. I don't know how many of you pick up the phone and call the Bar Association. If you watch this one TV program, my wife watches a lot of Botched.
We're hoping to finish it through this summer, and it is sorry, lost my train of thought there. The database it's set up so that any type of misconduct in any jurisdiction could be able to kind of fit into it. And there's different levels of confidentiality, to get to your second point. And so we don't share everything we collect with the Innocence Project. Our attorneys make kind of notes on cops' profiles as well. And there's certain case-specific information or stuff that happens in some of our sealed cases that we put in our database that is blocked from anything we're sharing with other defender organizations.
And so there are these screens so you can obey protective orders and everything else. But the question about finance, right? The one thing that was so extraordinary to all of us is that Julie and her partner, Cynthia Conti-Cook, were able to invent this, right, and get it into the cell phone for comparatively little money. And the most important thing, and Frank would know this better than anybody, but it does seem to be that scalability is the key, that we want to develop. Obviously, it should be open source, and we want people to be able to just, as a turnkey operation, be able to install this. Now, we had 1 year ago, Conti and I presented this to the National College of Forensic Science, and that is selected federal defenders and public defenders from all across the country, trial and appeals, who are trained trainers. And we got an instantaneous response, even from jurisdictions like Florida, where all this record is public, and we said to them, well, you can get this information, tomorrow, just by making an Open Record Act request. How do you guys notify each other that the police officer, maybe didn't tell the truth in some kind of a search and seizure case last week? And they go, oh, well, it's just word of mouth, which is crazy in the era of big data. The other thing I should point out about this is that now I do a little deep dive for lawyers, okay? The United States Supreme Court has recently indicated in the Strieff case and Heir that they are not really inclined to suppress evidence, even when there's a Fourth Amendment violation, unless you can show that there is a pattern or some kind of intent. And there were dissents in that case by Judge Ginsburg, Judge Sotomayor, who were saying, well, how is anybody ever going to get this data, right, about these patterns? Well, just take a look at these databases. You will find those patterns, right? And that actually can happen. And it's not just to please the United States Supreme Court. It is a good thing, because Chief Ramsey is going to want to know if there's a pattern and practice of violating the Fourth Amendment at certain places under certain circumstances. And by the way, we are now in the era of body cams, right? My Lord, I was here at the Quattrone Center not too long ago when the people in Los Angeles began explaining to us all the problems in terms, they can't even see the entire body cams that are coming in. They have people that basically look at them and tell them where to look, right? And as this comes online, and as we get all this other data, as we have in New York and Chicago and Los Angeles about crime drivers and different people in different jurisdictions, there is a lot of Brady material, totally unstructured, as our colleague Andrew Ferguson has pointed out, that is buried in prosecutor offices that nobody even knows how to retrieve. So following the chief's admonition, we have to start constructing these databases and sharing information in very smart ways. But yes, it can be done comparatively cheaply. All these defenders want to come forward. They all want to do it. If we gave them a modest amount of money to train, Julie would come in and train them, and others, just staff it. They're going to find that after a year, they're going to want to find some way to pay for it themselves. And this is where the virtuous cycle comes in. Because once somebody does either a defense or a public database in your jurisdiction, everybody's going to want to start to get at the data. That is going to change everything. And that is, there are very few recommendations one can make where you can say, if you do this, this is going to virtuously change the way people behave in the criminal justice system in a jurisdiction. It's an unusual kind of investment.
All right, dude. So let's talk about it. New York City Legal Aid Database, Brady Law Compliance versus the Chicago Invisible Institute Database, which was started by journalists. So I think it's time to start the Alabama Invisible Institute Database, because Legal Aid's not going to give us theirs. And there's nobody at Legal Aid. There is a Legal Aid in Alabama, but it is not what you're thinking of. It's civil, not criminal legal aid.
Yeah. I'm having a tough time with this, to be honest with you. I mean, I'm not a fan. All right. I like data. I love metadata. I love algorithms. I mean, as far as the curating and sorting and extrapolation and interpretation of data, I'm all for it. I think that's a very scientific way to do just about everything. I mean, every scenario involving artificial intelligence has ended with basically an artificial intelligence being used where you just feed it data and you ask it questions. And because this artificial intelligence has such a massive amount of data already digested, already curated, already sorted through millions and millions of algorithms, that they'll give you the correct answer every time. And I'm all for that. However, on the same side, I'm not a big fan of lists, especially not.
Okay, it's a bad cop list.
List.
It's a bad cop list. Cops that have been convicted of doing bad things. And the idea that that's not handed over to the defense at the onset of a trial is unbelievable.
Right. There is a national sex offender database. You get on that list, buddy, you're not getting off of it. And except in very, very, very rare, very extravagant cases, you're not getting off of it. So I understand that there are lists out there. I don't like the fact that a list like that follows you everywhere you go for the rest of your life.
No, for your career as a police officer, Raines. Very different than the rest of your life. I'm talking about cops.
I think it's a slippery slope.
Okay, well, you're wrong because they already have a master name index, and I'm on it.
What's the difference between that and the master name index? I mean,
because there's a public purpose for this index, the Alabama Invisible Institute database. Absolutely, there would be a purpose for it. What would the purpose be? So that we know who the bad cops are.
Because anything using the word invisible shouldn't be allowed in the state of Alabama or Mississippi or Texas.
Okay, well, we'll come up with a better word for it. But besides the vernacular, I think it is, and you just heard Barry Schreck say, this is somewhere you can put money and you can bet your ass that you're going to get a change in the system almost immediately.
I can understand that. However, what's the shelf life on a tool like that?
There is no shelf life. It continues to grow, and it's like you say, when you hang up your badge, you come off the list. Why would we want to keep up with you, unless you're ancillary to some other people that are in their little lawnmower man globe of data?
There's so many databases that we keep. The federal government has databases on so many different things.
I'm not talking about something they keep. I'm talking about something that somebody like this group would curate.
I could definitely see it as an idea, and I can get my head around it as an idea. I think you're going into dangerous slander and libel laws.
No bullshit. Not if it's something that's substantiated, man. It's not slander to put on a public website that this cop, the U.S. attorney in the Southern District in Mobile will not rely on this cop as a witness. Why wouldn't we all know that? Why wouldn't the judge know that? Why wouldn't the defense attorneys know that? It's a problem, and it shouldn't be compartmentalized.
And it's like I said earlier, but on behalf of private investigators and special investigators everywhere, please don't put us out of a job by making a list like this. This is incumbent on anybody who wants to find these things out prior to a trial. A lawyer with any half sand would say, all right, let's look into these cops. Let's look into all our witnesses. And that's what they pay people like me to do. And I'm happy to keep doing it as long as I get paid for it.
Right, but you're talking about somebody that's on the hook for the rest of their lives, and they're willing to pay $25,000 for a defense team, not just an attorney, but several paralegals and an investigator to work on their case. Whereas if you had a database like this, and your guy's coming to you saying, "Hey, man, I don't know where the hell this cocaine came from. I certainly wouldn't be driving this piece of shit car if I had a kilo of cocaine." You understand what I'm saying? Well, if we had a database that Deputy Dipshit has planted evidence on somebody before when he was in, working for Mobile County Sheriff's Department, and now he's at the Bay Minette PD, why wouldn't we know that? Well, we've already established that APOST, Alabama Police Officer Standards Training Commission, is a cover your ass organization. Right. They don't even have a complaint form Right. It's irrelevant. It's ridiculous that we even spend money saying that we have a police officer standards and training commission. We do have one. I don't know what the hell they do. All right, dude. Well, that's it for me. We've gone about 2 hours. Anything else about this? This is going to be my new project.
I'm gonna have to sleep on it. I've got a lot of thoughts about it, and honestly, to use the word curate, I've really got to curate my thoughts on this and organize it. And
we'll go back and think about the three buckets. The 3 buckets that California uses is a good way to go. And it's like what was her name? Julie Coccolini. She said that yes, they have access to this information, but unless the attorney can somehow weave it into why his client should be given lighter bail or why we should dismiss these charges, it's not really usable information, and not everybody's going to have access to that. Only the legal aid attorneys are. I would say, in Alabama, we don't have attorneys that are appointed like that for indigent people. Each of our 3 circuit judges have 3 attorneys that work under a contract, and they're always friends of theirs that get the contracts. Just remember, I was the first one that related that to you. Well, anyway, we got to do a little outro real quick, okay?
Hello, my name is Ed Wilson. At the present time, I live up in New England. I've been a professor at Harvard University for almost 50 years, 42 active, and the rest emeritus. But I grew up in Alabama. I was born in Birmingham. I characterize myself as an Alabamian who went up north to get work, and I found it here. But I've stayed with that state. I've loved that state. As a boy, in places like Bruton, Pensacola, and Mobile, I used to go out on field trips, collecting animals and catching butterflies and the like. And I thought then of lower Alabama, that I was in a paradise. I turned the Alabama experience then into a global experience. And so I spent long periods of time in places like the Amazon, the South Pacific, Africa, and collecting ants, studying ants, in the course of which I have discovered new species, and the number is 450 species, new species I've discovered and given a name to. I think from the point of view that I'm speaking of a scientific naturalist, of a person who spent his life working on biological diversity around the world. I think that I can speak with authority. Alabama is biologically, faunistically, and floristically, and environmentally the most interesting state in North America. It's hard for me to conceive of anyone being against the environmental movement. I mean, after all, we're talking about cleaner water. We're talking about conserving our natural, irreplaceable resources. The environment movement itself is, I think, conceived by some of the people you would say are anti-environmentalists as a part of an ideology that is left-wing, wishes to seize control, to make the environment movement as part of a larger left-wing agenda. About all I can say to my friends and colleagues who think like that is, oh my, must you? My goodness, don't you really believe in the spirit and the goodwill of your fellow Americans? I think we're going to work this out to everybody's favor. I'm a supporter of the Southern Exposure Program, strong supporter. It's vastly better as a method of teaching and developing allegiance to the idea of saving and using wisely Alabama's environment than would be any number of lectures or required courses in schools. And I'm confident it's going to be contributing a lot to environmental education in the state. Well, you've gotten a lot of panegyrics out of me and a lot of patriotic speeches and comments. And they're all sincere. You know, I do anything I can to promote the state that I owe so much to.